All right, welcome to another episode of Discussions from the Frontline. I'm Cara from AMPS, the Australian Medical Professional Society, and today our guest is human rights lawyer Peter Pham. Peter Pham is principal lawyer at Maat's Method, and Peter's goal is to defend universal law, the inherent dignity and rights every man and woman hold by virtue of their humanity. Up until 2019, Peter worked in private practice before being employed as a human rights specialist lawyer at LegalAID New South Wales. Soon it became clear that those places weren't aligned with Peter's values, nor would they accept his unwillingness to consent to an impingement on his bodily integrity. Peter founded Maat's Method so that he could work on the front line throughout 2020 and 2021 on various court cases on the topics of censorship of medical and other professionals, the right to not consent to unwanted medical procedures, privacy and whistleblower laws, and other human rights areas, particularly those enshrined in international law. He remains one of the few lawyers in Australia working in these areas. So welcome and thank you for joining us this morning.
My pleasure, Cara. Nice to talk to you today.
So thanks so much for taking the time to speak to me early on this Monday morning and share your knowledge on these critical issues. So can I start with what made you do what you're doing? What has it made you question the government response to the pandemic and decide there were legal questions that needed to be answered?
I have always had lots of problems with the way that the government administers its power in Australia. And I see the pandemic as an intensification of issues that already existed, but existed in a more subtle way and in a way that didn't affect as many people. That's why I became a human rights lawyer. And for a long time, for a few years, because I'm not that old, I was able to practice in human rights law in a way that didn't really ruffle too many feathers, because they were issues that didn't affect the large majority of the population. So it was sort of quiet and easy for me to do what I thought was right and to stick to my values and principles and remain autonomous in what I wanted to do. In early 2020, late 2019, COVID rolls around. And for a couple of weeks, I was like everyone else. I thought, what's going on here? This is pretty worrying. And then I came across some pieces of information which very early on led me to believe that something wasn't quite right, and that the messaging we were receiving from government was at the very least not based on science and data, and at most was something more than that. I began to work I was employed, like you said, at LegalAID New South Wales, which is a government-funded legal service for people who can't afford legal representation. I was in the human rights specialist team, so I was working on, there's a bit of a conflict there because it's government funded, and we would sue the government for breach of privacy, discrimination, intentional torts, so things like malicious prosecution, false imprisonment, whistleblowing and stuff like that. But it sort of existed in this way that worked as long as you didn't push things too far to the point where maybe LegalAID's funding would be in jeopardy or something like that. So there were limitations there. COVID rolls around and I started working on a lot of the issues surrounding COVID on the side. So there were lots of privacy issues. There are issues of informed consent. There are lots of employment law issues with vaccine mandates, issues around the public health orders. And for a while that was okay. And at that time, there was only probably 2 or 3 lawyers in all of Australia working on these issues. And I have to give a lot of credit to those lawyers. Serene Tefahar, who's had her practicing certificate removed, was instrumental in beginning a lot of this work. Tony Nikolic, who a lot of people know from AFL lawyers. There's many other lawyers. A lot of the people who listen to this will know Julian Gillespie, who was working on these issues early as well. And there are a few others as well. But I was doing my own stuff on the side, mostly helping individuals. And then I began writing articles, for example, one which questioned the validity of the public health orders. And that stuff started to go quite viral. And my employer didn't like it very much. and there were complaints made about me, which I won't talk about too much, but there were complaints made about me to various legal bodies and things like that. I had a choice to make, like many Australians, and the choice was, do I remain authentic? Do I follow my principles? Do I stand in what I believe to be true and just, or do I compromise? And my wife at the same time, who had just fallen pregnant, had the exact same situation at her work as well. And we both made the same decision, which was, we can't compromise. We have to stay true to what we believe in. We have to remain steadfast in our principles. And we left traditional employment. And the only way for me to continue to work on these issues, which I consider human rights issues, but most human rights lawyers in Australia don't, was to start my own firm. So I did that. And since then, I've been working on mostly these cases, although I do still practice in other areas of human rights law as well. But COVID-19 is the most widespread human rights issue of our time, the surrounding issues around COVID-19. So that's become the majority of my work.
Busy.
Yeah, very busy, very busy. Yes. Yes.
So like you were saying, you wrote a number of these articles, which I have read quite a lot of them. The arguments on human rights, the lawfulness of public health orders, the responsibilities of public servants and that sort of thing. And I found them, probably like many other people that read them, quite eye-opening, because I'm not a lawyer. So it was very interesting to see you pull together all the different acts and the human rights and all of that, and lay out an argument that was actually quite easy to understand. So thank you for all of that work. And I'll get you to discuss some of them as we go through. But before we start discussing those letters, can you explain the difference between the State Human Rights Act and then the Australian Human Rights Act? Because there's two states, Queensland and Victoria, that have human rights acts, and then we've got our Australian Human Rights Act. Could you just explain the difference?
Yes. It's probably best to just explain first something, which is that you'll hear many lawyers say, they'll sort of wring their hands or wash their hands and say, we don't have a human rights charter in Australia, we don't have a Bill of Rights, which is true. What we do have are some state-based acts, as you mentioned, and an Australian Human Rights Commission Act. And there's also some legislation that enshrines various human rights areas that Australia has legislated for quite well, such as privacy. There's a Federal Privacy Act, and discrimination law. There are both federal and state discrimination acts. The reason why I start by explaining that we don't have a Charter of Rights is because, unlike, for example, ironically, New Zealand, which might surprise people, Canada, the United States has a constitution which enshrines a lot of their rights, without exception in many cases. So unlike those places, Australia doesn't have a sort of source of knowledge you can go to and say, these are our human rights. The state-based acts that you refer to, such as the Human Rights Act in Queensland, their main purpose is to bring into existence and then facilitate the operation of state-based human rights commissions. So in Queensland, you have a Human Rights Commission, a state-based Human Rights Commission. There's also the Australian Human Rights Commission Act, which brings into existence the Australian Human Rights Commission, which is a federal body with and I think we'll talk about this, but who have a function, which is to advocate for and defend human rights. Something that a lot of people don't realise, including a lot of lawyers, is that the Australian Human Rights Commission Act, which is the federal act, so that covers all of Australia, it actually includes within it the various international covenants and treaties that Australia as a country is a signatory to. So when people say human rights aren't enshrined domestically in Australian law, that's a little bit of an oversimplification. There are mechanisms in Australian law designed for protecting human rights. One of them is the separation of powers. The courts and the executive, the government, are separate. And the whole purpose of that is when the government goes a bit too far and breaks the law, the courts are supposed to make sure that the law is being followed and to hold those politicians to account accordingly. That's a very important human rights protection that exists in the makeup of the Australian Federation and society. On top of that, you've got the Australian Human Rights Commission, who are a federal body whose function is actually to protect and defend human rights in Australia, including the international covenants and treaties Australia has signed and agreed to enforce. When Australia signed the ICCPR, the International Covenant on Civil and Political Rights, in the wake of a great human rights tragedy, in the wake of the world wars, and it's that kind of solemn tragedy that gives rise to such things as countries agreeing to enshrine very important universal human rights principles. When Australia signed that treaty, they agreed to actually also enforce it, to actually, by signing that treaty, you agree as one of the articles to make sure there are mechanisms in place to ensure that the various human rights protected in that treaty are actually protected in domestic law. And one of the ways Australia has done that is to pass the Australian Human Rights Commission Act in the 1980s, and the Australian Human Rights Commission comes into being. And the function of the commission, as stated in that act, is to protect human rights principles. And the act even includes the ICCPR and other international covenants in it, which means there is a piece of domestic law in Australia which actually includes the various international covenants and treaties in it. That's important because the state-based acts, and I know this is a bit of a roundabout answer to your question, but the state-based acts don't do a very good job at actually protecting human rights. Why? Because there are very discretionary and loose exceptions that the government can rely on, state government usually can rely on, but other potential breaches of human rights as well, in order to say, well, yeah, we didn't comply with the act, but it's because we thought it was best not to, because there's some situation we consider to be critical. And the issue is that we consider, if there's a discretionary opt-out clause that allows, for example, a state government not to have to abide by a piece of human rights legislation in the state, then the legislation isn't very useful, because the breacher of human rights is almost always the government. And of course, they're not going to do something and say, we're breaching human rights because we're breaching this act. They're going to have some kind of justification they're relying on to do so. So what I try to do is, when people are looking at what are my human rights, a good place to start is actually to read, for example, the International Covenant on Civil and Political Rights. Be careful of those who seek to dismiss it summarily and say it has no power in Australia because it's not enshrined domestically. It's a little bit of an oversimplification, and I always question the motives of people who say that. Read it and you will see that actually it is quite a powerful document, which if more people were aware of and, for example, asked the Human Rights Commission to uphold and protect, as is their statutory function, things like impositions on informed consent, impositions on free speech and freedom of expression, impositions on liberty of movement, impositions on self-determination, would be much more difficult for the government to justify.
So, building on from there, what is an actual human right? So we've got a commission that's supposed to protect them. What are they?
Yeah, good question. Unfortunately, it sort of depends who you ask. I'll tell you what I think. I believe in natural law and universal law. I believe that each human being, inherent within their humanity, is entitled to rights. Well, let me change the language. Already has rights, not entitled to them because nobody can provide them to you or take them away. That's a bit of a philosophical opinion that I hold. In terms of the law, I would probably use the Australian Human Rights Commission Act to define human rights. And I can read you the definition actually, because it's important. Human rights means the rights and freedoms recognised in the covenant, i.e. the International Covenant on Civil and Political Rights, declared by the declarations or recognised or declared by any relevant international instrument. So I think probably the fairest way to define human rights in Australia is to look at the international covenants and treaties Australia has signed and agreed to uphold, because the whole purpose of Australia's presence in those agreements is that we're saying, as a part of The fallout from World War I and World War II, where so many human rights were trampled, and everybody around the world realized, well, we probably need a universal system of recognizing what the inherent dignity of each human being deserves. Otherwise, we might fall into a situation like this again. Well, let's look at the definition that Australia agreed to uphold, 50 years, well, 70 years ago, 60, 70 years ago. It's not that long, although we have short memories in this day and age. Let's look at that definition, because it's a pretty good definition, and the international covenants do a pretty good job of enshrining human rights principles that have actually existed in human society for tens of thousands of years in various forms. Today, in our current society, there is a huge move away from good and evil, away from truth and fiction, towards these relativist ideas of your truth and my truth and her truth and his truth. And that makes the ground very shaky, and it's very difficult for things to be defined very clearly. And I think that's intentional, and I think that's very dangerous. Instead, we need to have a solid foundation for things like what is the definition of human rights, so that breaches of human rights are very easy to spot and then easy to snuff out when they occur. Good way to set that foundation is just to look at the international covenants and treaties. In particular, what's most relevant to COVID is the International Covenant on Civil and Political Rights, and we can talk about that if you want.
Yeah, I do have that in my questions.
Okay, sure.
But the next one, before we go there, just sort of expanding on some of the stuff you've already said, is in Queensland, which is where our headquarters is, we have the Human Rights Act, and under Division 2, we have what's called override declarations, which is essentially what you were saying, where human rights can be overridden in situations such as a state of emergency. Now, the
language is actually even looser than that. And I don't know it off by heart, but it's something like the intention of this act is that the government only override this in a state of emergency, and there's a few other examples as well, which is even less strict than that, which just shows you that there's baked into the act is an ability to opt out, as you say. But sorry to interrupt you, please continue.
Yeah, no, that's all right. But that's very interesting, because like you were saying, human rights came out of mass violations of human rights, and oftentimes, in those state of emergencies, that's when you need your human rights protected the most. And within this, we've got a capacity for the state to grant themselves the ability to override human rights and make orders under, like, for example, the public health orders, to do whatever they deem reasonable with no definition of what is reasonable. And if you've got human rights that are universal, and when you read on the international covenants and stuff, they call them non-derogable, so they cannot be suspended, how do you write an act with a capacity to suspend human rights that are not supposed to be able to be suspended in any circumstance?
Yeah, that's a good question. There needs to be there needs to be a very significant recognition within the populace, within the community, that human rights are important. Australia does not have a good track record of, as a country, acknowledging the importance of human rights. There are lots of reasons for that. One of the reasons is Australia is a very young country, if you look at the colonial history of Australia. Another reason is, in that time, so since 1788, there hasn't been any great tyrant or revolution or civil war or something which has made people really realize, oh crap, maybe we should have some protections in place for our human rights, until the past couple of years, where suddenly people are locked in their homes and being told they must undergo provisionally approved medical procedures and they have to wear certain things and so on. Now everybody's paying attention, but before that, nobody was. And that allowed the government to create and sustain a system that does not recognize or acknowledge or respect human rights very much. That needs to change. And the only real way for that to change, you said, how can an act be created? Well, Parliament creates legislation. If a Bill of Rights or a Charter of Rights was to be put into place, that would help. The only way any government is going to agree to do that, because they're the ones who breach human rights. So the only way they're going to agree to do that is if enough of the population pressures them to do it. Governments act existentially because they want to remain in power. If their power is threatened, they'll change something significant like that. So we really need people to actually be a lot more loud and proud about the importance of the rights that they care about. And to be honest, we need people to say no when there's something occurs which doesn't align with their own principles or with their own definition of human rights. I think that most of the people, I assume, listening to this call would agree, for example, with the importance of informed consent and bodily integrity. When there is a state-sponsored imposition on those principles, if 10% of, let's say, the population disagreed with that and very actively took steps to conflict with it. And I'm not talking about violence. I'm talking about professional action. I'm talking about refusing to engage in certain practices. If 10% of the population did that, it would fall over straight away. And that's a maxim in sociology, that no system can sustain itself with 10% of the population in opposition to it. So as cliche as it is, it comes down to individuals, and that's beginning now because of what's happened in the past couple of years. I hope things don't have to get too dire for enough people to stand up and do what AMPS is doing or other organizations are doing.
Okay. So let's go on to your letters, many which I have sitting on my desk highlighted and written all over.
Oh, gee.
So this is this one, so which you can't see because of the blurring.
That's all right. I think I know which one it is. Yeah.
Yeah. So the statutory function of the Australian Human Rights Commission.
Yes.
So can you explain to everyone the role of the Australian Human Rights Commission, what their duty is? In your letter, you outline the functions of the Commission under this Act and other acts with regard for the indivisibility and universality of human rights.
Absolutely. Australian Human Rights Commission's whole purpose for existence and the reason they came into being is because of a particular article within the ICCPR, which obligates the Australian government to ensure that the agreement that it agreed to, being the ICCPR, that it signed, which does mean something despite the government sometimes acting like it doesn't, they agreed that they would implement mechanisms and bodies who can actually enforce the protection of those rights. The main way they've done that is by passing the Australian Human Rights Commission Act, which brings into existence the Australian Human Rights Commission. In any statute's good because it's objective, it's written, it's very easy to identify what the purpose of the law is, as opposed to common law, where sometimes there are arguments around what it means and what it applies to. Statute is very clear. And the Australian Human Rights Commission Act is a good act, which very clearly outlines the duties and functions of the Australian Human Rights Commission. And unsurprisingly, the duty of the Commission, and this is a little bit confusing, but there's duties and functions. So the duty of the Commission is to ensure that the functions of the Commission are administered with regard to human rights, and particularly, as you said, with the indivisibility and universality of human rights. How are human rights defined in the Human Rights Commission Act? It's the definition I gave before, by reference to the international covenants and treaties, any relevant international instrument. A relevant international instrument is one Australia has signed, but it's in particular, it's one that is included in the Act itself, in the schedules, such as the ICCPR. So that's the duty of the Commission. Functions of the Commission, i.e. the reasons the Commission exists. There are several, but to point out, to pick out three very relevant ones. One is to inquire into any act or practice which is inconsistent with or contrary to any human right. That means if there's any practice or act which is inconsistent with any of the rights in the ICCPR, and just to give a very brief overview of some of those. First right in the ICCPR, which is usually regarded as kind of the bedrock of human rights, is self-determination, the right of an individual to freely engage in society, irrespective of their political views, irrespective of their medical status, irrespective of their race, whatever, religion. The right to freely determine the course of your own life, that's self-determination, absent any kind of pressure or coercion. The right to freedom of thought and freedom of expression. AHPRA have not respected that right very well over the past couple of years, as well as many of the councils, professional councils across the country. the right to liberty of movement, as I said, that's obviously been restricted by state governments in particular and territory governments. The right to not to be coerced into engaging absent free consent in medical or scientific experimentation. People get a little bit triggered when you call the COVID-19 therapeutic goods or vaccines, if you want to call them that, experimentation, but they are provisionally approved products yet to complete clinical trials. Obviously, their efficacy is shifting because people are being told to have them on a more regular basis, the accepted efficacy profile. There are thousands of peer-reviewed papers. I don't really need to tell your audience this, but there are thousands of peer-reviewed papers which call into question the efficacy of those products. They have been described as experimental by Greg Hunt. There shouldn't really be a debate as to whether that's medical experimentation or not. And certainly many people in Australia, millions of people in Australia, arguably everybody in Australia has been coerced into engaging into medical and scientific experimentation absent free consent, because the consent was not absent political pressure, economic pressure, social pressure, and other forms of duress as well. So the ICCPR has lots of important and very relevant rights, and the duty of the Human Rights Commission, one of the functions, I should say, very important functions, is to ensure that any act or practice which might be inconsistent, it's very broad, which might be inconsistent with any of those rights, that they inquire into that practice, i.e. they hold an inquiry where the proponents of that practice are forced to produce the evidentiary basis for it and to explain, yes, we derogated from Article 1, the right to self-determination. Here's why we did it, and is that acceptable? And then that can be determined in a transparent manner by both the public and the appropriate executive members. That hasn't occurred. Another key function is to perform functions with respect to equal opportunity in employment. So Section 31 and 32 of the Human Rights Commission Act is all about equal opportunity in employment. I'm sorry to talk so much, but there's little things I have to explain in each of these things. So one of those is that a lot of people in Australia, lawyers and even the Human Rights Commission actually, have said at various points in time that medical status is not a protected attribute, so therefore you can't be discriminated against on the basis of your medical status. That's only partially true. It's not a protected attribute in the sense that the various state and federal acts which protect certain attributes from discrimination, such as race, age, sex, disability, there's no medical status discrimination act. So yes, it's not a protected attribute in that sense. However, the Australian Human Rights Commission Act, in its definition of discrimination, includes medical status as one of the grounds on which somebody can be discriminated against. And that definition applies to Section 31 and 32. So Section 31 and 32 of that Act empower and give the responsibility, the function to the Human Rights Commission to actually inquire into any act or practice in Australia that might impair which might cause discrimination against people on the basis of their medical record or medical status. And obviously in Australia, almost every private company and government department have discriminated against people on the basis of their medical status in the past couple of years. You can't work here if you're not vaccinated against COVID-19. There are lots of problems there in employment law as well, which is a separate topic. But for now, I'll just say the Human Rights Commission has a duty, very, very clear duty. There's no exceptions in the Act. Very clear function. To this section, there's no exceptions. Clear function to inquire into any practice that might cause discrimination against people on the basis of their medical status. And very clearly that's occurring. The third function, which I'll just quickly say, is if there's any enactment or law which is proposed or brought in by government, which might again have the impact of impairing human rights, the Human Rights Commission is supposed to look into that. And again, none of that seems to have happened. In fairness, I did receive a response from the Human Rights Commission to this letter. So in this letter, I laid out the functions of the Human Rights Commission, and we asked them 20 or 30 questions, we being myself and Julian Gillespie. Why have you not complied with your functions under the Act? Because Human Rights Commission has a very, very, very important responsibility when it comes to human rights in Australia. In a country that doesn't have a charter or bill of rights, these bodies are absolutely necessary to ensure that the executive does not step over the line too far and implement measures, even in the context of an emergency. And there are obviously arguments about whether there was an emergency or not, and whether the emergency that was purported to exist was actually explained to the people in a transparent way and justified, and so on, and all of that should have occurred. But leaving that aside for a second, even if there is a genuine, very serious emergency which requires the government to take massive action, let's say a war or something like that, where liberty of movement may have to be restricted or something like that, the Human Rights Commission is still supposed to make sure that they act as the kind of balancing stick, and they hold the government to account, and they say, if you're going to breach these human rights, which our function is to protect, you must clearly explain to us and the Australian people what the basis for those breaches are. Where's the scientific basis? Where's the evidentiary basis? What are you hoping to achieve? How long is it going to last? That would have been a great minimum if they did that. Really, they're actually obligated to do more than that, which is to actually hold an inquiry. Why is that important? Because if governments and politicians know that they're actually going to have to explain what they're doing, they're actually going to have to provide the evidentiary basis for their decisions are going to be very different. The past 2 years has seen politicians in Australia, state and federal, make decisions without any fear of accountability, because they think that they're untouchable and they won't have to explain the reasons and evidence for their decisions. And that's why their decisions have been so ridiculous, because they haven't been forced to be held to account. And the Human Rights Commission is one of the best placed bodies to do that. And it's not a controversial thing for them to do. It's part of their function. It should not be a political question. It should be a question of, what do we exist to do? We exist to protect human rights. If you're not too creative with it, the definition of human rights is pretty clear, and it is pretty clear that human rights have been impinged upon in the past couple of years. Most state and territory governments to some extent have admitted that, but they've then sought to justify it with an emergency. First of all, on that note, I would say the international covenants are very careful to only allow, they're not like the Queensland Human Rights Act, where the exception, the override clause, is very broad and easy for a government to use. They're much more careful than that, and that's because they're better drafted and they're more honestly drafted with a focus on actually protecting human rights. And for example, the ICCPR, the exceptions there only come into play if the life of the nation is at threat, and the exigencies of the situation specifically call for the specific derogation from the human right, i.e., the entire life of the nation has to be a genuine threat for any of these human rights to be moved away from. And the exigencies, so the specific details of the situation, have to call for that specific temporary breach, and the signatories have to then write to all the other people who have signed the agreement explaining that they're going to derogate from it and why. And there's lots of other checks and balances in place to make sure you don't just derogate from it and say, sorry, we had to do this because here's our very short press release which just says why, but doesn't give you any evidence or information about it. It's much more careful than that. And of course it is, because we're talking about human rights, which are indivisible and universal. And if there's any acceptable reason to move away from them, which is an argument in and of itself, it needs to be very, very, very careful and measured and temporary. And Australia has weaseled its way out of that so far by relying on our lack of a Bill of Rights, lack of a Charter of Rights, and in many instances, in my view, misinterpreting laws that do exist to protect human rights, and people who are in positions to actually do something like the Human Rights Commission not doing what they're supposed to do. And that has led to the situation that we're in now.
And what was their response to you?
Oh, sorry, yeah, I went on a tangent. I received a response from the Commissioner. She said that she's also very concerned about all of this. She's relatively new to the role, and it's one of her focuses moving forward, essentially. That's what she said.
How new?
I think she's been in there now for about, well, it's been about a year. So not very new. It's been about a year. I don't think she said she was new, but she said that it's one of her focuses moving forward. And the impression I got from that is that that's what she's saying. I don't think that's a sufficient response, personally. I think that she didn't really, or they didn't really engage with the substance of the letter. And we're hoping to have the questions in the letter canvassed in the form of a parliamentary inquiry to encourage a more detailed and careful response, because it's not, yes, it's good if they change their approach in future. Who knows? Maybe they will. But a lot of damage has been caused in the past few years. Millions of people had their livelihoods affected. Thousands of people have died. The excess death for this year is way above historical norms. The leading cause of death is cancer and diabetes, i.e. neglect. And the measures of the past few years have had a direct impact on that. Whatever you think about the COVID vaccines, I know from talking to people all the time and doing the work that I do, there has been, and you can look at the TGA's own database of adverse event notifications as well. There have been hundreds of thousands of serious adverse events reported to the TGA. There have been thousands of deaths reported to the TGA. Questions of causation aside, because people like to raise that, the large majority of reports made to the TGA are reports made by doctors and medical professionals who, despite the pressure not to do this because they can get in trouble by overzealous medical regulators, are putting in a report and saying, this is my patient who I've treated for years. I have seen them undergo this therapeutic good or provisionally approved vaccine or whatever you want to call it, and they have suffered this reaction, I believe, in my professional judgment as a result. There's this idea that it's not reliable data. It's very reliable data. And the physical harm that's occurred to people is incredible and unprecedented. Obviously, people losing their jobs, the decimation of small businesses. There are broader strokes to all of this, such as the move towards digitization, the huge losses we've had in people's privacy over the past couple of years that people aren't even aware of, and what these QR codes and vaccine passports could lead to if we're not extremely careful. All of this is extremely damaging, and the Human Rights Commission has a very important job to do to make sure that those rights aren't actually permanently affected in the way that they could be and will be if either the citizenry doesn't stand up or these bodies don't. Really, a combination of both is what we need.
All right. So in one of your other letters, just moving away slightly, it was titled "The Curious Case of the Unlawful Public Health Orders."
Yeah, that got me in a lot of trouble, that article. Yes. It got removed as well from, it's been removed from, I mean, it was originally posted on LinkedIn and they've sort of banned it. You can't, anyway, I'm glad you've got it. Yeah.
I've got it, I've read it. So this one outlines the areas of laws, human rights, international treaties, as you discussed, that you believe have been breached and not defended by those who are entrusted to protect them. I've got a lot of it you've already covered a bit, but which areas of rights and laws of other acts do you feel have been violated and misinterpreted, potentially?
Oh, there's many. There are many. I believe the public health directives and orders themselves were a misappropriation of the various public health acts in each state and territory. The court recently emphatically disagreed with me, I should say, because a similar argument to the one I made in that article recently got before the federal court, and they lost. It lost. But I still personally believe that the public health acts which were used to create these public health orders and directives in each state and territory were not intended to be used that way. The clause in each state and territory act was, I believe, misappropriated for that purpose. I don't think it was ever supposed to be the case that the state minister for health in Queensland and New South Wales and Victoria and so on was able to restrict the liberty of movement of the entire state in one individual autonomous stroke. That is entirely inconsistent with the way our society works and with the law. That's one example. The Privacy Act is a federal act which is being breached every day still by many companies in Australia, and they don't even know it. And the penalties are huge. There is potentially going to be this onslaught of litigation if that's where this goes. About all of this. The Privacy Act is a big one that's been breached. To give you an example, companies are supposed to be extremely careful with the sensitive information of their employees. There are very strict rules about the collection of that information when it's appropriate, and when it is collected, the level of security that needs to be applied to it, a level that most companies don't have, because they're not. Why would a company before 2020, why would an insurance company or a cafe want to protect collect its employees' medical status? It would have seemed ridiculous, their medical records. But nonetheless, that's the world we're in now, and they don't realize that if they want to do that, they have to comply with many provisions within the Privacy Act. Many of the government's own apps and digital mechanisms for QR code check-ins and vaccine passports don't comply in many cases with the Federal Privacy Act. In employment law, the Work Health and Safety Act and the Work Health and Safety regulations, that in each state and territory there are equivalent acts. They're all very similar across the states and territories. Some of them are identical, and they outline the responsibilities and the duties of employers as in relation to their employees and vice versa. Again, I don't believe that within the regulations, for example, the control measures which employers are allowed to implement in order to mitigate risks in the workplace include the imposition of a mandatory medical procedure for staff. I don't think that that is within the scope of the legislative scheme that governs the employer-employee relationship. That question of law, which is a question of law, has not yet been determined, let's say, by the federal court, who are the body that have the jurisdiction to hear questions of law. All of the cases have gotten stuck in the Fair Work Commission and the Industrial Relations Commission. They don't have the jurisdiction to hear questions of law. So instead, they're making all of these decisions on this assumption that vaccines are extremely effective, and the only real fail-safe way to mitigate the risk of COVID-19 in the workplace, which is ridiculous and factually incorrect, and that COVID-19 itself is this deadly virus that we're all at huge risk from, which again contradicts the science and the data, or at least the science and the data which is not conflicted through funding and other things. So employment law is going to be another area of litigation probably in future. I don't think that these policies are lawful and reasonable. Again, a court has not agreed with me on that point yet. I believe it's inevitable though, especially as the truth comes out with respect to vaccines, efficacy and safety profiles, the efficacy and safety profiles of the vaccines. There's more as well, discrimination law, discrimination on disability discrimination. There are arguments around whether, most employers and businesses are only accepting formal contraindication certificates. But as you probably know, you have to almost die from a first dose of a vaccine before you can get one of those. And you might not get one even in that circumstance. And doctors who issue them are applied an unfair level of scrutiny, which offends their professional judgment and unfortunately affects the willingness of doctors to provide those certificates. Regular medical exemptions, which should be enough, are enough under disability discrimination law, because if you suffer from any kind of disability which precludes you from engaging, let's say, in a particular form of employment, the employer has the onus of proving why that discrimination is lawful. And a good reason is not because you don't have a particular kind of certificate and we don't accept that certificate that your doctor lawfully issued. That's not a good reason. It needs to be a reason that actually complies with, for example, the Federal Disability Discrimination Act. There are exceptions in that act, but there's an argument that needs to be had there. It's not a matter of bypassing those arguments. All of this will come out in the wash because it's inevitable. We're getting much closer to a lot of that happening. There have been a couple of positive results in the courts, and more are coming as things become more transparent. but there's so much of the past couple of years that we'll look back on incredulously with respect to the law and other things as well.
Right, well, on sort of more legal stuff, which is your specialty, there's a lot of people have raised the issue of fully informed valid consent and the coercive strategies that you were talking about to get people to comply. A lot of people talk about the immunisation handbook, and the definition of valid consent is the voluntary agreement by an individual to a proposed procedure which is given after sufficient, appropriate and reliable information about the procedure, including the potential risks and benefits, has been conveyed to the individual. And the criteria for valid consent, for consent to be, and this is a direct quote from the immunisation handbook, for consent to be legally valid, the following elements must be present. And it says legally valid. It must be given by a person with legal capacity and of sufficient intellectual capacity to understand the implications of receiving a vaccine. It must be given voluntarily in the absence of undue pressure, coercion or manipulation. It must cover the specific procedure that is to be performed. It can only be given after the potential risks and benefits of the relevant vaccine, the risks of not having it and any alternative options have been explained to the person. And then in the Good Medical Practice Code of Conduct, 4.5, informed consent is a person's voluntary decision about medical care that is made with knowledge and understanding of the benefits and the risks involved. So a lot of the arguments have been by governments to say, and even some courts, if I remember correctly, is the injections are voluntary. You can choose not to have it, but there are consequences of not choosing. But if you choose not to, you literally lose everything in many people's cases, your ability to feed your family, your career, which some people might have worked decades to achieve, your ability to participate in society, your ability to have an organ transplant in Queensland, and your ability to visit dying relatives. And so I know what this sounds like to me, and it certainly isn't voluntary and free from coercion. So what are the legal issues around informed consent that like health practitioners probably need to consider and be aware of?
The first legal issue around informed consent is that prior to 2020, everybody just assumed that it was sacrosanct and that it would not be manipulated or bent or misappropriated as a concept. You referred to various policies, codes of conduct, regulations that enshrine and define informed consent, all slightly differently, but the principles at its core are the same, which are that it is consent absent any form of duress or coercion. And that's always been well understood in the medical profession. As you say, there is the Australian Immunisation Handbook, there is the Healthcare Complaints Commission policy, there is the Code of Conduct for doctors. There are many, many, many policies and regulatory documents which define informed consent. What those things don't do is statutorily enshrine them, because they're not statutes, they're codes of conduct and regulations and policies, which is the seed of doubt which has allowed, for example, the New South Wales Supreme Court, which I think is the court you were referring to before, to essentially say last year in the Kassam case that informed consent, well, two things. One, that informed consent is not statutorily enshrined. And secondly, that people aren't actually being forced to be vaccinated. They're just being faced with a choice. And it's this sort of semantic argument, which I don't agree with at all, which purports to say that you still have a choice in this situation, even though, as you say, you'll lose your job, you might not be able to get a heart transplant, you'll be blocked from your dialysis treatment, you can't visit your dying grandfather, whatever. So why do I say that? There are statutes in Australia, such as the Mental Health Act and the Guardianship Act, that define informed consent in specific reference to those areas. So the Mental Health Act, for example, has a very detailed, very good definition of informed consent, which very clearly has everything that should be there. The patient has to be completely informed about the nature of the treatment, what it might do, the long-term effects, what the alternatives are, et cetera, et cetera, et cetera. The Guardianship Act, in the context of guardianship disputes, has a similar definition as well, but they only apply to those areas. There's no Informed Consent Act, and there's no, as we said before, Bill of Rights that domestically enshrines a consistent universal definition of informed consent. And because this has never been a great issue before, that means that what we have are various policies and codes of conduct and regulations that everybody has just kind of created for themselves. When I say everybody, various medical regulators and so on. And doctors have always taken for granted that informed consent was going to be is going to be something that is core to their practice, and not something that's going to be challenged or that they're going to be asked to bend or divert in some way. In terms of the common law, in medical negligence, there is a bit of a history of the courts defining informed consent. There are cases where definitions for informed consent have been given, again, in a manner that sort of assumes that it's something that exists and is enshrined. But that's not necessarily the case. So in medical negligence, for example, doctors or the insurers of doctors can be held liable for failing to warn their patients of risks with respect to treatment or surgery. And that obviously bleeds into informed consent, because if you're giving proper informed consent, you're warning your patient adequately about everything that might go wrong with a particular procedure. And this is one of the problems with COVID vaccines. Doctors have been banned by AHPRA as of March 2021. I don't believe they actually have that power, but that's a separate issue. But doctors have been banned by AHPRA from going against essentially the government narrative around vaccination, from doing anything which might call into question the government rollout of the vaccines. And that has often been interpreted as including a doctor saying to their patient, you know what, you do have a history of heart conditions and blood clots. I think you should probably wait a few years at least before considering these vaccines, because one of the acknowledged adverse reactions which might result from them is myocarditis, and one of the other ones is pericarditis. And there hasn't been sufficient testing to conclude that these correlations between lots of adverse reactions in the form of myocarditis and pericarditis aren't actually more common than many people realize, that they won't actually turn up in 10 years as opposed to in the 20 days or 30 days window that the vaccines actually clinically tested for these adverse reactions to appear in the first instance. So doctors and their insurers might get in trouble in the future if there is an appropriate move towards acknowledgement that actually a lot of the injuries that we're currently seeing, but most people aren't looking at very closely, are causally related to the vaccines, which is, again, this is all inevitable. The data is such that it's very clear what's going on, and it's just a matter of time before societal acceptance catches up to what is currently a little bit rebellious or controversial to say. You know, it's the old thing about cutting the head off somebody and thinking that 4 heads aren't going to pop up instead. The more you try to silence someone or something, the more that it's going to build momentum and come to the fore and come to the surface, and that's inevitable anyway. I can't remember what your question was. I've gone off on a frolic of my own, I think. What was the question again?
It was about informed consent.
Informed consent. So in short, it's not enshrined in any reliable, consistent way, which is a problem. We all kind of assumed that it was something that was enshrined. It needs more protection and solidification in reference to what's happened over the past couple of years. However, there is a long line of common law which asserts the importance of informed consent. There are various cases, but Marion's case is one of them, which is a High Court case. There's the John Hunter Area Health Service case from 2019, which asserted that whenever there's conflict between what the state wants to do and the right of an individual to freely consent to something, the rights of the individual will always win. There are all of the various policy documents of all the medical regulators and so on, which do contain definitions of informed consent, which need to be probably enshrined and need to be and doctors and professional staff as well need to probably raise this issue a bit more with the regulators. I know that's easier said than done, but to say to them, look, if I comply with the code of conduct and actually provide my professional judgment to this patient, I'm in conflict with the AHPRA position statement of 2021, and I think that's a problem. And if enough doctors and professional staff did that, they would have to change something. But power in numbers is very important in an environment where the brave individuals who stand up are being attacked. There needs to be a collective. That's very important.
Right. Sorry, my phone's going off. All right, next. So both the handbook and our codes require discussions of the risks and benefits of therapeutics. We're all constantly hear from the authorities the safe and effective claim. And I recently read a letter from one of the ministers that said proven safe and effective. So from the chief health officers, the health ministers, but like you were saying, these are on a provisional pathway. They've been approved via this new pathway for registering medicines, which I think was 2018. And then the middle of last year, the Therapeutic Goods Regulation Act had amendments made to it to remove section B and C, which seem to reduce the requirements for demonstrating certain safety and efficacy standards. So how are they able to keep getting up and repeating this safe and effective? And then how do we appropriately discuss the risks and benefits under, like you were saying, the AHPRA position statement, as well as when these have commercial in confidence protections, so you can't even fully discuss what is contained within?
When you say we, do you mean
like health professionals?
Health professionals. I would say.
How do you meet those handbook and code of conduct obligations?
Well, the first answer is you can't. You can't comply with the code of conduct and comply with the AHPRA position statement of March 2021. They are in conflict, which means one of them is invalid. I would argue that the policy statement of a regulator whose statutory authority to actually govern doctors is questionable in the first place, and I'm referring to AHPRA, I'd argue that that one loses out. However, the reality of the current situation is that doctors are being forced through disciplinary processes almost as a punishment. That's how it seems to me anyway. And I can completely understand why an individual practitioner would not want to be put through a process like that. It's extremely traumatic. It usually means that they lose their career anyway, irrespective of what the decision is. They're put through months and months of protracted legal proceedings. It obviously has an impact on all other areas of life as well. So I get that. But you can comply with. AHPRA put out a statement a little bit later where they said, if what you're talking about is peer-reviewed science, for example, you won't get in trouble. There is a lot of peer-reviewed science that a doctor can provide to their patient. For example, if their patient is concerned about the lack of testing and efficacy and safety of those particular products. As time moves on, and I'm hoping this happens sooner rather than later, there needs to be collective action on the part of health professionals, as the example we're currently talking about. Same thing needs to happen in law, the same thing needs to happen in society at large. But there needs to be collective action taken, because that's the only way that these inconsistencies will be fleshed out and flushed out, and that the true, for example, data that's coming out now will hit the mainstream, data around the excess death in Australia this year and last year, as opposed to pre-COVID times, and a proper scrutiny and investigation into the causes for that, of which, of course, it's multifactorial. But obviously, if there are, I think it's 10% more deaths, and I'm not 100% sure about the number, but it's something like that, than there were in 2019. And before, I don't know if anybody listening to this would think this, but the leading cause of death is not COVID. It's not even in the top few leading causes of deaths. So something has happened, something is going on, which is exacerbating people's health problems, whether it's neglect because shutting everything down means people don't get access to healthcare, whether it is health problems which are stemming from pharmaceutical products which have suddenly become mainstream in the Australian population, whatever it is, we need to look into that. As for doctors, how can they avoid the overreach of AHPRA? The example of Dr. Paul Oysterhouse, I think is his name, is a pretty good example. He pointed out one of the ways in which doctors are being prosecuted outside of the scope of the law through his own experience. You can read about that on, I think he has a blog, which I read a few months ago, I think, which was very good. And I agree with him that Section 150 of the national law, which is the public interest, public protection section, does not really apply to many of the doctors who are being disciplined under that section. And if it does happen to you, there are ways of pushing back that are likely to succeed. I can't say that without seeing each individual case, because everybody's different. But again, the law has been misappropriated a little bit, and it's punishment through the disciplinary process itself, rather than something that will actually result in a permanent suspension or cancellation of somebody's practicing registration. So there are ways around it. I don't think there's anything wrong in general with a doctor complying with the code of conduct and providing informed consent to their patient. If AHPRA really tried, well, it would be the medical council, for example, or the dental council, or whoever it is, if they really tried to prosecute somebody and that professional said, I was complying with the code of conduct. It says I have to do what's best for my patients. I have to provide informed consent. I have to inform them of the risks. That's what I was doing. I think it would be very, very difficult to prosecute that professional. And I haven't seen any cases like that, actually. They've all been for, the ones I've seen and represented people in, it's been for things like social media posts or involvement in groups that are anti-vaccine or other public things where people are sort of advertising their position on the issue. I haven't seen any cases where a doctor has actually just informed their patient of risks associated with the medicine and then been disciplined for it, because that would be a good one to run, actually. If anybody's in that situation, it'd be a very powerful one to run.
All right. On the AHPRA March 9 position statement, because you've spoken a little bit about that, it does essentially make questioning the public health orders a form of professional misconduct equivalent, or it seems to be equivalent to being a threat to public health. That's what a lot of them have been suspended under the immediate action clauses, as a threat to public health and safety for questioning or undermining the public health orders. How is that legal? Because the position statement is a statement using part of the national law to set a guideline or a position statement as part of your code of conduct. But it seems to be in conflict, like you said, with our oaths and codes and informed consent and other legal requirements. How is it that it hasn't been challenged essentially over the last 18 months, more successfully challenged?
I'll answer the first part first. AHPRA is not the medical council. They do not have lawful authority to, in and of themselves, govern the practices of doctors and professional staff.
Well, by all the boards, though.
Well, that's the thing. It's the boards who actually have that statutory authority, but only under the auspices of the national law. The national law is the Health Practitioners Regulation National Law. It governs the discipline of medical staff in Australia with respect to public health and safety, essentially, and other things too. What's happened so far is that medical boards and councils have sort of just fallen into step with AHPRA. And if a doctor, for example, calls into question the government's narrative around the Pfizer vaccine or whatever, they've said, oh, well, we think you're a risk to public health and safety, and they've instituted proceedings against that doctor under Section 150 of the national law. There are other relevant sections as well, but Section 150 is the one that says to a council, if you believe that a doctor is a threat to public safety, you must suspend that doctor, essentially, is what it says. So there's a problem in the way it's phrased, because it puts the onus on the council to suspend somebody if they believe that that person is a threat to public health and safety. That section of the law has been misused in many cases, like Dr. Paul Oysterhouse's case. I'm sorry if I'm mispronouncing his name, but I think that's how you pronounce it. Because that section of the law only applies in the context of the Act if the council forwards first to the tribunal, such as the Queensland Civil and Administrative Tribunal or the New South Wales Civil and Administrative Tribunal, is one in each state and territory, the complaints which form the basis for the suspension. And then it's the tribunal, if you interpret the Act properly, the national law properly. So the tribunal who's supposed to suspend somebody's registration. So there's been, again, a little bit of a bending of how the law works to fit a particular desired outcome, which is to stop doctors speaking out about COVID-19. That is generalized opinion, not legal advice. I'll just clarify that. But it's something that people can look into further if it applies to their individual situation. The second part of your question is why hasn't there been an overturning of all of this? Well, Dr. Oysterhouse had his overturned because he threatened to file proceedings in the Supreme Court. I think he did file them in the Supreme Court, asserting that the jurisdiction was misapplied of the national law and therefore his suspension was invalid. His suspension was overturned because that, in my view, was a proper interpretation of the law. The only way for all of this to be overturned in a effective and final way is if a court, such as the Supreme Court, makes a determinative conclusion of how Section 150 of the national law is supposed to be applied. This is one of the problems with the legal system. In order for that to happen, a doctor has to have his, let's say his or her license suspended or cancelled, let's say under Section 150. Then they have to challenge that in the tribunal. Then they need to apply to the court to say, for example, that the law has been misapplied in the tribunal, or they need to escalate a question of law to the court, because again, the tribunals usually can't just determine questions of law. So they have to go through the tribunal, then they have to get to the court, then they have to bring proceedings in the court, then the court needs to make a decision. What's much more likely to happen along the way is either the doctor or nurse or dentist or whatever gives up, or they settle the matter somehow, whether they agree to some condition on their license, or they get some kind of monetary settlement, or something else happens and they agree to drop the case, which in most of the ones I've seen, that's what's happened. Because to get all the way to the court, you're talking about a year of legal proceedings and lots of costs, and it's huge stress and anxiety, and your relationship is in trouble and everything else is going on. And you can't practice during that time unless you negotiate that you can, but that's very difficult to do. So it's just the case that the cases have not been heard yet that will very clearly determine. These are all new, novel issues, and legal precedent needs to be set. And in employment law, the national law with respect to professionals, and AHPRA is kind of stepping into the shoes of power that they don't have, and Privacy Act and all these other areas. It seems like, because our legal system is so slow administratively, usually, it's going to take a couple of years, unfortunately, for the law to be clear. But it doesn't mean that individuals can't agitate these issues and get a good outcome for themselves in the meantime. But unfortunately, it's not as easy as it should be yet. It will change.
Well, I've got one more question because we're a tiny bit over time. I've only got a couple of minutes. So you've spoken about a lot of different things, and self-determination, all the different laws, our human rights perspectives. One of the things I'm quite interested in is, are there any legislative responsibilities on our public servants, like our chief health officers, our chief medical officers, the head of the TGA, AHPRA, TAGI, health ministers, premiers, essentially all of the people that are making and implementing these decisions? Are there any acts to which they are accountable for the decisions they make? So a lot of the health advice is still secret health advice. We're not entitled to know as their constituency on what evidence they're making these decisions. There doesn't appear to be any review or accountability of the risk benefits of each of the decisions. They don't seem to be in line with our pre-COVID pandemic preparedness plans. And there's no ongoing review of, are we doing the best for our constituency? Are we meeting our obligations under the Act? Is there anything that to which they themselves are accountable for the decisions they make and the outcomes and consequences for the people that they are supposedly representing or there to serve?
Generally speaking, in my view, that's a very good question, because one of the things I've been looking into a lot is what statutory duties do our public servants have that we can hold them accountable to in the context of the last couple of years. I would say this is my general opinion, and then I'll be more specific and tangible. Generally, our legislature is very careful, I think, to draft legislation that does not create statutory duties for the executive, which is not a good thing. That's a very bad thing, because it removes accountability and transparency. However, we still have the separation of powers, and we still have laws. We still have judicial review, for example, which is the ability to, for any citizen, well, any citizen, as long as they're found to have standing, to bring a matter in court alleging that an error of law has been made in the decision of a minister, for example. We also have something called a writ of mandamus, which is another cause of action where you can compel a minister or politician to comply with one of their duties. Some of the more recent well-known examples of that in the context of COVID, and there haven't been many of these cases launched, but I think it's one of the better angles to take, to find an error of law, i.e. a politician or minister or member of the executive who has not complied adequately with their statutory duty, and to canvass in a court their lack of compliance with that duty. Why is that a good approach? Because it's based on a statutory obligation, which is objective. Well, as close to objective as you can get in law, which isn't quite objective, but it's a lot closer than common law, where a lot of these things like informed consent are floaty and difficult to pin down because they're defined in all these different places. And we don't have a Charter of Rights or a Bill of Rights, which says, for example, bodily integrity is a right of the populace. Therefore, in Kassam, the Chief Judge of Common Law, Justice Robert Beach Jones in the Supreme Court in New South Wales, can say something like, bodily integrity is not a right that Australians have. That's not a direct quote, but that's pretty close to what he said. And the reason he said that, or could say that, is because you can't point to some act or statute and say bodily integrity is enshrined. But this is a good question you ask, because there are some acts that do present statutory duties for particular people, such as the Therapeutic Goods Act, which presents a duty for the Secretary of the Department of Health to follow certain procedures and protocols when, for example, approving the use of a therapeutic good. And the basis of some of the cases I've been involved in the federal court is to force the secretary to comply with those duties under the Therapeutic Goods Act and Therapeutic Goods Regulation, and therefore, for example, not to administer a product to 5 to 11-year-old children unless the product actually has the effect of mitigating a serious or life-threatening condition. And in the current AVN case, which is currently before the federal court and is going to appeal a week from today before the full bench, one of the key questions is, and to some people here, this might not be much of a question, is COVID-19 a debilitating or serious condition for 5 to 11-year-old children? Obviously not. I don't think anybody credibly argues that it is. So therefore, was it appropriate for the Secretary of the Department of Health to approve the vaccines for that age group when he's only supposed to do so in those circumstances? That is a question of law that the federal court can answer, contingent on what happens on the 8th of August when that matter is next being heard. But there are some statutory duties and obligations that do exist people like Julian and myself and Serene and Ben Clemens and Tony Nikolic are trying to identify and work on those. But there aren't as many as I think there should be. And I do think the legal system in Australia is so flexible and malleable and lacking in solid foundation that in a situation where the powers that be have a very clear opinion about something and a very clear vested interest in something, it's not as easy as it should be for individual citizens to enforce their own rights and to apply the law in an objective way. So it's not a very satisfying answer, but I think that's the best answer I can give.
Well, thank you. Thank you for
Pleasure.
time, for all the work you're doing and all the great answers and information that you've just provided. Thank you.
My pleasure. No problem. Thanks for your time.
Have a wonderful day.
You too.